Today, when said about the judgment of Joseph Stephen versus Santhana Samy, feeling aggrieved and dissatisfied with the order dated on 14/5/2020 by High Court of Madras, the order was to set aside the order of acquittal passed by First Appellate Court and has convicted the accused. The original accused were charged and tried for the offence punishable under Section 147, 148, 324, 326, 307, 506 of IPC, and thereby acquitted the accused under Section 307 and 506 of IPC. When said about the or mentioned about the sections, as we all know, Section 147 of IPC, whoever is guilty of rioting shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or both. When discussed about Section 148 of IPC, whoever is guilty of rioting being armed with a deadly weapon or with anything which used as a weapon of offense is likely to cause death shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine or with both. When said about 324 of IPC, voluntarily cases hurt by means of any misandment or shooting, stabbing or cutting, or any instrument which is likely used as a weapon to cause death by means of fire or any corrosive substances. Section 326 of IPC means voluntarily causing by dangerous weapons or means. Section 307 IPC, attempt to murder. Section 506 of IPC, punishment for criminal intimidation. Whoever commits the offense of criminal intimidation shall be punished with imprisonment for either description for a term which may extend to 2 years or fine. When said about the judgment dated on 18/1/2023, allowed the appeal preferred by the accused. The criminal appeals filed by the victims against the accused of the accused under Section 307 and 506 clause 2 IPC came to be dismissed. So under 401 CRPC, the High Court set aside the order passed by the First Appellate Court, that is, acquitting the accused and consequently convicted the accused. So the High Court therefore modifies the sentences imposed by the trial court. Sri S. Nagamuthu learned, senior advocate, appealing on behalf appearing on behalf of the accused, submitted that the High Court has redeeming, reserving the acquittal and convicting the accused. He relied upon Section 401 subclause 3 of CRPC and asked that he has no jurisdiction to convert an acquittal into convicted. When said about the section which is mentioned here, 401 subclause 3 of CRPC, nothing in this section shall be deemed to the authorization of the High Court to convert a finding of acquittal into one conviction. The case referred here are Chinnaswamy Reddy versus State of Andhra Pradesh, Sheetal Prasad versus Srikanth, Ganesh versus Sharanappa, and Ram Brigade Singh versus Ambika Yadav. 3 years Nagamuthu on behalf of accused submitted that after the amendment in section 372 CRPC that states that the victim shall have a right to prefer an appeal against any order passed by the court acquitted the accused or convicting for a lease of offense. And said about the other case, the Mallikarjuna Kodagal versus State of Karnataka, the court that where the victims preferred on appeal against acquittal, he has an absolute right on the appeal. It is also submitted that the victim in the present case were having a right of appeal to the High Court against the order of acquittal as provided under Section 372 of CRPC. The advocate on behalf of the accused opposed the prayer and made a respondent to it. It's also submitted that firstly, the High Court have to pass a judicial order to treat revisional or application as patients of appeal. And when said or discussed about the question is that arised is whether the High Court under Section 401 CRPC is justified in setting aside the order of acquittal and convicting the accused by converting the finding of the acquittal into one of the convictions. The High Court also considered another accept of matter. The two contingents which arise out was if in the case the trial court may acquit the person, and in such a case, if the High Court is justified to interfere with the order of trial court, the only thing which can be do is set aside the acquittal and consider the case back to the trial court for reconsideration. On the other hand, if the trial court have convicted the accused while the appeal court have acquitted him, so the High Court may order to rehear the appeal, and this depends upon the facts of the case. And when said about in the present case, only defect is that the appeal court wrongly ruled out the evidence which was admitted by the trial court. So it directed the appeal court to rehear the appeal and either maintain the conviction after taking into consideration or to acquit the accused. In the case of Sheetal Prasad, it prohibited the conversion of a finding of acquittal into one of conviction, and it's in such a case, rehearing of appeal is ordered. So when said therefore, the influenced common judgment and order pass revising the acquittal and convicting the accused is hereby set aside. The matters are transferred to High Court. The High Court is directed to treat the revision application as appeals under Section 372 CRPC and thereafter to decide and dispose the same in accordance with the law on their own merits. So the present appeals are accordingly allowed in the aforesaid terms. And that's all. I'm concluding by saying that.
All. So now I shall elaborate on the first issue, that is whether the High Court, in exercise of its revisional jurisdiction under Section 401, can set aside the order of acquittal and convicting the accused by converting the finding of acquittal into one of conviction. So we have an express provision by virtue of Section 401 Clause 3. There is a bar because an order of acquittal cannot be converted into a conviction in exercise of the revisional power of the High Court. But we can see an exception in CRPC itself in section 386 clause A, which deals with the powers of appellate court, which says that the appellate court has the power to reverse an order of acquittal and find guilty the accused and pass the sentence. So although there is an express bar in the High Court is only having a bar on the revisional power in converting the sentence of acquittal into that of a conviction, while it grants the appellate court to do so. But in exercising the revisional jurisdiction, if the High Court comes into such a situation, and if the High Court finds that the trial court has erred in doing the justice, and if there is a manifest error of law or procedure which has been done by the trial court in acquitting the accused, what is the procedure to be adopted what is the procedure to be adopted has been elaborated in a decision, Chinnaswamy Reddy versus State of AP, AIR 1962, Supreme Court 1788. So, in that case, it has been briefly stated that if the order of the trial court is, if it is passed by the trial court, then the High Court can remit the matter to the trial court for retrial. A second is, if the order of acquittal has been passed by the first appellate court, then the High Court has two options. That is, one is to remit the case back to the appellate court to rehear, or else to remit to trial court for the retrial. So this is the procedure to be adopted by the High Court in exercise of revisional jurisdiction when it comes with such a situation. So the first issue has been answered likewise. And regarding the second issue is concerning if there is a right of appeal, whether that is, there is a right of appeal to the victim or the complainant, but it has not been preferred, then in such a situation, whether a revision application is required to be entertained at the instance of the victim. That is the second issue. Regarding that, there is a provision in section 401 itself, 401 clause 4, which says that if there is a right of appeal and no appeal is brought, then no proceeding by way of revision shall be entertained at the instance of the party who could have appealed, because in such a situation there is two other express provision which grants the victim as well as the complainant to prefer an appeal. That is, by virtue of 2009 amendment, a proviso has been added to section 372, which says about the victim statutory right of the victim to appeal against the order of acquittal. And second is situation is section 378 clause 4, section 378 clause 4, which gives the right to appeal with a special leave by the High Court. Grant of special leave to appeal by the High Court. These are the two circumstances. So in this case, we can find that instead of preferring section 372 appeal, 372 appeal or 378 clause 4, here we should not consider about 378 clause 4, because here it is a victim appeal. So instead of filing an appeal under section 372, the victim has preferred a criminal revision petition. So it is expressly barred under section 401 clause 4 of the CRPC. So no revision is to be entertained at the instance of the victim against the order of acquittal in case, because no appeal is preferred. So that is about the second issue. Hence, the third issue is regarding third issue is whether the High Court, while exercising the powers under Section 401 Clause 5, is required to pass a judicial order. We can see in 401 Clause 5 that the High Court, when a situation arises when the victim or the complainant have the right to appeal, but a criminal revision petition has been filed, the High Court has the discretion to deal with the same as a petition of appeal and deal with the same accordingly. So, in such a situation, when the High Court decide to treat the criminal revision petition as an appeal, it has to pass a judicial order and treat the application of revision as a petition of appeal. In such a situation, it is necessary that it shall record its satisfaction. It shall record its satisfaction.